Good afternoon and welcome to the first PACO General Membership Meeting of our term. My name is Teresa Scharf. I'm currently serving as president of PACO, and I would like to introduce the other officers of your organization. We have Andrea Enderle, who is our vice president. We have Kemily Kwok, who is our assistant vice president. We have Jamie Warner, who is our treasurer, and Garth, who is our secretary and archivist and photographer. So he kind of wears a few different hats. Again, we want to thank you for coming. Thanks to those who are logged in with us online and trusting that you can see this and hear this clearly. And we're pleased, so pleased to thank Anderson Reporting, Justin and Dan, for being here to take care of the technical side of this. Thanks to Gail Anderson for always being such a great supporter of PACO and all the things that we do through our professional organization of paralegals. I just want to do a quick rundown just to give you an idea of what you've missed or what you've participated in over the last few months. In September, we had our biennial workshop and exhibition, which was famously attended. We had almost 100 people. That was hosted at Capital University Law School, and several paralegals, several law firms, several other vendors were in attendance, and we had great speakers, including Lisa Pierce-Rice, who is the president of the Columbus Bar and a partner at Voorhees, among several others who were there that day. In October, we had an evening event called PACO Boo that we hosted at Miller's Tavern, I think, and we had about 24 people who came to that and seemed to have a good time. In November, we hosted our annual Wills Clinic CLE for volunteers who volunteer at our pro bono Wills clinics throughout the year. The room was packed for the CLE. We had about 60 people in attendance for that, and then afterward, there were about 40 who came to a mixer that we hosted at a restaurant down on South High Street, and had a great time with that. And then just a few weeks ago, we hosted yet another mixer in the evening after work at Penn's on North 4th Street and had about 18 or 20 people attend that. So this is our first actual lunchtime meeting. We're glad to see you here. And I want to just make a couple of quick announcements. The first is that if you have already taken the CLE to volunteer at our PACO LASC Pro Bono Wills clinics, we have a Wills clinic tomorrow night in Reynoldsburg, and we need 3 more paralegals. So if you have taken that CLE and you are available tomorrow evening, we'd sure like to have you come join us. We have 8 attorneys, and I need 3 more paralegals. We'll be serving 12 clients and maybe more depending on our time restraints. So if you are available, please send me an email at probonocolumbus@gmail.com, and I will send you the information that you need in order to join us. And then Andrea, is Cassandra here? Okay, hi. Do you ladies want to come up and share a little bit about what to expect upcoming here in a couple of months? I'm introducing Andrea Enderle again, who is our vice president, and Cassandra Struble, who the two of them are working on a big event that we do every year.
Hi everyone, this is Cassandra Struble. She is the chair for our programs committee, and we just want to quickly let you know that we are working on Paralegal Day, which is the day to celebrate paralegals and all of the great strides that we have made through our profession. Do you want to?
Yeah.
The date?
We are moving the date to May 14th, which is a Monday, and we are having it right now at Bluestone Wine Cellar over, I think it's off
Front Street.
Front Street. More details to come, but.
And this year we do have we have seating up to 100 people. So when you do get the information, don't dally. Make sure you register as soon as possible, because it's a really intimate venue and it is 100 seats.
Yeah.
So we'll see y'all then. Mark your calendars.
Great. Thank you, ladies. So we'll look forward to that and continue to watch the announcements that come out each week with information that we'll be distributing about events that are coming up in March and April in advance of the May Paralegal Day festivities. So without any further delay, I want to introduce our guest speakers, and I want to thank them for coming. From Bluestone Law Group, we have Attorney Charles Bluestone, and we have Attorney Patrick Heery. Charles has been serving Ohio taxpayers regarding property tax issues for about 25 years, and Patrick joined Charles in November of 2014 and is doing the same. Holly Swisher is director of Clarus Partners, which is a tax consulting firm. So I'm just going to turn the podium over to them. I believe Holly's going to share some insights with you first, and the other two gentlemen will then step in, and if you have any questions, please be sure to ask. For those who are watching us online with the live stream, you can send questions in via the chat, and we will get those questions asked to the speakers. Holly, thank you.
Hello, everyone. I am Holly Swisher, and I work for Clarus Partners. Thanks for having me. Clarus Partners, just to give you a little bit of background, is a accounting firm. They have a couple different service lines, state and local tax, with which I fall into from a property tax perspective. They also do corporate income tax as well as audit, and they handle a lot of small business accounting services for various clients across Columbus, and we are now starting to get a lot of clients that are national in scope. So a little bit of background about Clarus. I have been at Clarus since 2014, but I've been practicing in property tax profession for a little over 19 years. I started at Ohio State, and after graduation I moved to Chicago, with which I started property tax at Deloitte, and career ventured from there and made it back to Columbus after several years in Columbus and then a little bit of time in New Jersey. My role within the property tax area is my client base has properties across the country. And so I get involved in property valuation, looking at their properties from a dollar per square foot basis, from a valuation, talking with the local jurisdictions, figuring out what their property tax budgets are going to look like, making sure their property's values are in line with the market, comparing it to sales, income analysis, and so forth. How that factors into the way Ohio works with property taxes is, let's just say for Franklin County's sake, since that's where we're all sitting, Franklin County revals every 3 years. They do a revaluation every 6 years, and then they'll update their properties every 3. And so in that process, I am looking at my clients' values, looking at how things have changed, looking at new construction, demolition, etc., and then comparing that to what the county auditor comes out with a value. And I then reach out to individuals like Charles and his firm in regards to if I feel the property is valued higher than what the market is kind of giving me information on, or my clients demoed some stuff but the county auditor didn't take that into account. Then we kind of evaluate whether or not it makes sense to file a formal complaint with the Board of Revision within the county with which that property sits. And so I go through a lot of the pre-analysis as to determine whether or not there's a case. And then we do a lot of what we call cost-benefit analysis on whether or not it makes sense to pursue. And so that's a lot of my involvement with regards to Ohio. I'm also getting involved in properties with incentives and whether or not they are applicable for incentives, whether my clients are investing in things that there are applicable as incentives available to them. And so a lot of times they have in place an incentive agreement, and that factors into how the property is being valued, and that factors into how the property is also being taxed. And so a lot of my involvement there is making sure that the valuation is accurate with regards to the incentive agreement in place, as well as there's annual compliance that comes along with having an incentive agreement. A lot of times taxpayers agree to commit to certain amounts of jobs and or payroll or other, and they have to reach their commitments on an annual basis. And so we are getting involved with regards to that part of it and filing those forms and making sure they're in compliance with the different agreements with which they've committed to for the term. And a lot of the terms on some of these are either 15 years, 10 years, 30 years, depending on what type of agreement it is. And so I have also attended a lot of Board of Revision hearings, whether it be as a witness or as someone who is just participating in the process to hear both sides of the case from the taxpayer's point of view, the school board's point of view, or other. And so a lot of my history kind of evolves around real estate valuation. I get involved in a lot of personal property compliance as well. And so it just kind of depends on where my clients' properties are and what their issues or annual administrative matters kind of look like with regards to their portfolio. So that's a little bit of background with regards to what I do for my clients. Most of my clients are based in Ohio, but they have properties nationally across the U.S. So that's a little bit of background on Clarus Partners and what I do. So hopefully, if you have any questions, I don't know if you want to wait until,
That's up to you.
or I can take questions now, or yeah.
Oh, there are no questions online.
Okay.
So.
Got it. That'll work. I'm gonna hand it over to Chuck.
Hi. First of all, welcome to the PACO meeting, and I hope everyone's enjoying lunch, and I'll try to keep you awake by keeping the comments and information I'm going to provide to be perky and informative. Let me say that 35 years ago, after graduating from Rutgers College, I went to work for a law firm in New York on 42nd Street across from the library as a paralegal, and really enjoyed the experience there. And after a year, I then moved to a large firm called Couder Brothers, which was the oldest and the largest international law firm in the world, as a paralegal in the real estate department. And I was there for about a year before I went to law school. And so I fully understand how important the role is that all of you play in assisting attorneys in helping our clients to accomplish their objectives. And so while you may hear this from the people you work with directly, I just want to thank everybody for the good work that you guys do as a group, as paralegals, for the legal community here in Columbus. Bluestone Law Group is a boutique law firm. We focus on real estate law. We do a lot of acquisitions and sale and leasing and financing of properties for our clients. We sometimes get involved with tax incentives, as Holly mentioned. But by and large, the bulk of our work focuses on the real property tax appeal world. And every day we're down at the Board of Revision or at the Ohio Board of Tax Appeals or at the Supreme Court, and sometimes in the court system, fighting on behalf of property owners to reduce the county's valuation of their properties and thereby reduce the tax burden that they have to pay. Taxes in Ohio are administered on a county-by-county basis. You pay real estate taxes to the county treasurer. It's the auditor who assesses or appraises the valuation of the property. The county treasurer then bills the property owner for taxes, and the county commissioners then spend the tax dollars. The system is set up on a 6-year basis. In year one, the county auditor goes out and inspects and views all the properties in the county. In Franklin County, for example, there are 436 individual parcels of land, and every 6 years, the auditor is required to view those properties and to appraise them. And then he sets the value in year one. That value stays the same for year 2 and 3. And then in year 4 of the 6-year cycle, the county auditor will update the value based upon information that he or she is seeing come through the office in terms of market trends and sales prices, etc. And once they update the value in year 4, that value then stays the same for year 5 and 6. As Holly mentioned, we're sitting in Franklin County, and Franklin County went through the reappraisal process in 2017, Anybody who here or on the web who owns a piece of property, maybe a home or investment property, you got a letter in the summer of 2017 from Clarus Mingo, which said, for the 2016 tax year, the value of your property was X, and he was proposing to raise the value to Y for 2017. And property owners every 3 years have an opportunity to come in and meet with the auditor and discuss the proposed valuation change. In Franklin County, Patrick and I handled quite a number of cases. We took advantage of that informal process, which is now concluded, but in September and October, we met over on a couple of days with the auditor's staff, and we reduced property values by more than $20 million, which saved our clients collectively $650,000 per year in taxes. Multiply that by 3 years, and now you're about $2 million in tax savings by taking advantage of that once every 3 year informal review process. That's over in Franklin County. It's coming up this summer in Cuyahoga County and about 15 other counties around the state. And so if you have clients that have properties in the counties that are going through the reappraisal or the update year for 2018, take advantage of the informal process. But if they've missed that opportunity, there is a formal process, which I'm going to talk about, which is going to the County Board of Revision. And Holly mentioned a couple of the factors that she looks at as a tax consultant in determining advising clients whether or not to protest taxes. Some of the most common grounds for challenging the auditor's valuation are if property values have declined overall, if there's lower credit tenants coming into a property, increased vacancies, higher rent concessions, or functional or economic obsolescence. Another ground for protesting the county's value is that the county auditor just sets it too high for whatever reason. If your client believes that they can't sell the property for that price, they should do some investigation to see whether or not there's an opportunity to lower the value and lower the taxes. By the way, this is important to write it down. April 2nd, 2018 is the deadline to file a tax protest statewide. Typically, the deadline is March 31st, but when the 31st falls on a Saturday or Sunday, like it does this year, it gets extended to the next business day. So for 2018, people have until April 2nd, 2018 to file. And you can file either in person or by mail, as long as it's postmarked by April 2nd. And a lot of counties will take electronic or fax filings. Franklin County takes fax filings and electronic filings. I already talked about the date, the deadline date. Who can file the complaint? Most situations that you're going to be dealing with is where the property owner is going to file the complaint against valuation with the County Board of Revision. But school boards can also file a complaint when they believe that the property value is too low. Typically, school boards do this when they see that the county auditor's value, let's say, is $1 million, but the property has sold in a recent arm's length transaction for $3 million. So they'll go after the property owner to try to raise the value. I would expect that this year, school districts in Franklin County alone will file about 2,000 complaints seeking to raise property values. And again, those are most commonly done when the property has sold in an arm's length transaction at a price above the auditor's valuation. This is what the complaint against valuation form looks like. It's the same form. It's one page. It's used throughout the state of Ohio. You can either find it on the Ohio Department of Taxation website, or every county auditor that has a website will have the form available. And it's the same form in all 88 counties. It's 14 questions. Pat is going to talk about avoiding pitfalls in filling out the form, which we thought was particularly important for you folks, so stay tuned for part 2 of the presentation. In Franklin County, is unique in this, there is a residential data form that if you're filing a tax appeal on a single-family home, you need to file the second form as well. It's pretty straightforward. It's basically asking for information about rooms in the house and when improvements were last done in the house. When they talk about improvements, they're not talking about repairs. They're talking about major capital improvements. So not painting, not replacing a fridge with a new fridge, or carpeting with new carpeting. They're talking about building an extension, adding a fireplace, putting a new roof on, major capital repairs. Now, you'll sometimes hear about the $50,000 rule. When a party who files a complaint against evaluation is seeking a reduction in value of $50,000 or more, then the local school board gets notified and they have an opportunity to come in and participate in the hearing. Why the local school board? Because typically school boards get 60 to 70% of every real estate tax dollar. So being the governmental entity that benefits or loses most from tax appeals, they get to sit at the table. They get to present their own witnesses, they can cross-examine property owner witnesses, they can present their own appraisal report. Now, on single-family homes, school boards typically don't appear, but they will absolutely appear 100% of the time on commercial properties. So be aware that if you file a tax appeal, your client files a tax appeal on a commercial property, the school board's going to be sitting there. The school board has the right and will be asking cross-examination questions. Does an attorney need to be involved in the process? Technically, the answer is no. Property owners can represent themselves. Officers, directors of a LLC or corporation or partners in a partnership can represent the business entities. However, we would strongly recommend, because this is the practice of law and it gets technical sometimes, and it's good to have some skilled, experienced advocates appearing on behalf of the property owner, that when you're dealing with, certainly with commercial properties or higher-end single-family homes, that the property owner consider hiring an attorney. Paralegals can participate by assisting in filling out the forms, subject of course to attorney review. But a paralegal cannot sign the form, because that would be practicing law. How do you calculate a tax bill? Well, you take the property's market value, sometimes also called the appraised value, multiply that by 35%, which gets you the assessed value, divide it by $1,000, apply the applicable effective tax rate and any rollbacks, and that's how you calculate the tax to be paid. Here's an example. If you had a $100,000 home, that's the market value. To get the assessed value, you multiply market value by 35%, divide by 1,000, then you multiply that number by the effective tax rate, which here is 78.9%, 78.9 mils, to be technically correct. You get a tax number, and then on single-family homes, there's a reduction factor, and if it's the person's primary residence, there's a secondary reduction factor. And you apply the reduction factors, and then you wind up, in our example, with $2,416 of taxes that are due. There are two types of cases. There are what I call sale cases, recent arm's length transactions, where you come in and you present the purchase contract, the deed, the settlement statement, and the conveyance fee statement, and maybe some marketing material to show that the property was exposed to the marketplace. That's what you need to present in a sale case. And if you don't have a recent arm's length transaction, then you need to come in with appraisal evidence. Who hires the appraiser? Typically, the law firm hires the appraiser. That's my recommendation. Why? Because I want to keep all communications with the appraiser under the cloak of the attorney work product rules, so that those discussions and those communications aren't subject to discovery by the school district or by the county's attorneys. Also, we, after 25 years of practicing in this field, have a fairly good sense of the different expertise of different appraisers. So we know if we're going to look for a single-family home, who's good for that type of project. If we're going to do an industrial property, we certainly would go to a different appraiser. We also have experience in judging appraisal fees and know what's reasonable and where we should be negotiating. So having the attorney involved in hiring the appraiser is beneficial, because the attorney work product, we know who to call for different specialized projects, and we also have greater familiarity in terms of fees. There is a difference between a financing appraisal and a tax appeal appraisal. With a financing appraisal, they're looking at let's say if it's an income producing property, let's say this office building, for example, they're going to look at the actual leases in place and determine the value using the actual leases in place and actual expenses. For tax appeal purposes, appraisers use a different methodology. They use market rents, market expenses, market cap rates. And a market rent can vary from the actual because, think about it, the Columbus Bar Association has been in this space for 20 years. It's paying a lease rate that may have been negotiated 20 years ago and no longer is reflective of market. So for tax appeals, we're always looking at market rents, market expenses, market cap rates. And what is market value? Market value, to simplify this more extensive definition, is what a willing buyer, a willing seller, each being knowledgeable about the market, nobody being under duress, will pay for the property. Think about it in your own everyday example. If you own a house, you drive by, you see a sign outside a house that you like. Maybe you have a realtor for yourself, maybe not, but somebody calls the listing realtor. You look at the house, you look at the commercial property, and then there's a back and forth negotiation process, and nobody's under duress. There's no foreclosure sale, there's no bankruptcy, there's no receivership. There's true market negotiations and a meeting of the minds, right? That's how you get a contract, and you agree upon a price, and then you close. That's a market arm's length transaction. Nobody being related to each other by business, by blood, by marriage. We've mentioned the Board of Revision. In every county, there are 3 members of the Board of Revision. They're made up of the president of the county commissioners, the auditor, and the treasurer. In the 8 metropolitan counties and many other counties, the office holders appoint somebody from their staff to sit on the Board of Revision. But in smaller counties, you will actually see the office holders. In Franklin County, Clarence Mingo, Ms. Sullivan, the county treasurer, and Kevin Boyce, the president of the county commissioners, have appointed people that have been sitting as their representatives on the Board of Revision here in Columbus for at least 5 to 8 years. So these people, this is what they do every day. They hear tax appeal cases. They're familiar with market conditions. They're familiar with appraisals. They've developed an expertise. They're pretty knowledgeable. As I mentioned, the filing deadline, you can file today, but the filing deadline is April 2nd. And then the Board of Revision will give notice when when the request to reduce value is more than 50%. They give notice to the school board, and then eventually there will be an administrative hearing before the Board of Revision. They typically last 20 to 30 minutes. If you do what I did last week and take an hour and a half, you're going to get some angry looks from the board members. But we won the case. So usually 20 to 30 minutes. The hearings are generally held in the summertime. You can request a continuance if necessary. Typically those will be granted one time. Who bears the burden of proof? The party asking for a reduction or an increase in value. So if you represent the property owner, you're going to have to either come in with sale documents or appraisal evidence. How long does it take to make a decision? Usually 2 to 4 weeks. And most of the time, at the Board of Revision level, you're going to get a very simple decision letter. It's basically going to tell you the result. It won't give you any analysis. It's often frustrating because you don't know why. It doesn't happen to me, but well, it does occasionally. Why you lost the case, why you didn't get as much of a reduction. The decision letter tells you nothing other than the end result. You can, however, ask the Board of Revision to send you the audio tape of the decision. And so you can sometimes listen to what's an abbreviated discussion of why the BOR felt that one side's evidence was more probative of value and the basis for the decision. So that's something you should know as a paralegal. In Champaign County, the decision's pretty similar, except they'll tell you the assessed valuation before the BOR hearing, the result, and then what the increase and the decrease was. But this is typically what you see from the Board of Revision. No real analysis of the evidence. There's a right to appeal. The appeal period runs 30 days from the date of mailing of the decision. Let me caution you, it's not the date that your client received the decision. 30 days from the date of mailing. So look at the date on the decision letter. Typically they mail it out the same date. Know that the BOR is only required to mail the decision letter to the property owner, although as a courtesy they will frequently mail it to the attorney. Usually in 99% of the cases, you need to tell your client, if you get something in the mail from the BOR, they should contact you or contact your attorney right away so that the 30-day appeal period isn't missed. There's no way around the 30-day appeal period. Property owners can appeal to two different fora. They can either appeal to the State Board of Tax Appeals, which is free. There's no filing fee. You can do it online. Property owners can also appeal to the local common pleas court. There is a fee. Sometimes you can do it online. Sometimes you have to drive down to Dayton because they don't have e-filing, for example. Remember, like in any kind of civil litigation, you have to file the notice of appeal where? To the court that you got the decision from and the court to which you are appealing. So you file in every case 2 notices of appeal, whether you file with the BTA and the BOR, or you file the notice of appeal with the Common Pleas Court and the BOR. You have to file the notice of appeal in 2 places. And remember to attach a copy of the decision that you're appealing from and a certificate of service. At the end of the day, hopefully you and the attorney and the property owner have presented a case with reliable, probative, and substantive evidence, whether it's the sale documents or the appraisal evidence, and then you get the payoff. You may get a $700 check on a single-family home, a $1,400 check for vacant land, a $5,000 check for a golf course, for example, maybe a $13,000 refund check on a small neighborhood retail center, a $20,000 refund check for a fast food restaurant, $107,000 on an office warehouse building located in Hilliard, Ohio. Maybe it's $122,000 on an apartment complex, or when you add these up, $2 million if you own Fort Rapids Indoor Water Park and Hotel. So there could be big payoffs from doing tax appeals. If you're unhappy with the BTA decision, there used to be, until this year, I think this year, there used to be an automatic right to go from the BTA to the Ohio Supreme Court, an automatic right. There was no requirement to file a memorandum of jurisdiction asking the court to take the case. People had the automatic right. And so I used to go to the Supreme Court and sit in on hearings, and people would come up and say, this case involves $600 in taxes. And it was shocking because you had the justice of the Ohio Supreme Court having to hear and write decisions on a $600 tax case. Well, the Supreme Court got fed up and they went to the General Assembly, and just a few months ago, they stopped that. And there's no longer an automatic right to appeal to the Supreme Court. So now, if you're at the BTA, the Board of Tax Appeals, your next level of appeal is to the appropriate Court of Appeals. If you have a case that goes to the Court of Appeals and your client believes that it's a matter of constitutional importance or great public interest, you can ask the Supreme Court to take the case and jump over the Court of Appeals and hear the argument directly. But that's going to be in rare circumstances. So most of the time now, it's going to be Board of Revision to the BTA to the Court of Appeals, and then if a further appeal is sought, you have to file a memorandum of jurisdiction asking the court to take it. As I said, there are about 43,000 properties, parcels in Franklin County alone. There's 146 different taxing districts. These are combinations of cities, municipalities, townships, and school districts. So I live technically in the city of Columbus. My kids would go to plain local New Albany schools. Somebody literally across the street from me lives in the city of New Albany, and their kids go to New Albany schools, different tax districts. Every one of the 146 tax districts has a different effective tax rate. And you can find the effective tax rates for each year on the county auditor's website. I've filed tax appeals on my own house, and so does the president. He filed a tax appeal recently on the infamous hotel in Washington, the old post office building. The local assessor in Washington, D.C. thought it had a $163 million valuation. And there was a settlement. and he got a 32% reduction, and he avoided around $2.2 million in taxes annually. Not only did he file on his hotel, he filed on his golf course down in Florida. The president says that it's the greatest, it's the world's best golf course. He thinks it's worth $50 million, but when the Palm Beach County assessor valued it at $19.7 million, the president went in and challenged the valuation for the golf course as well. So, from a mere attorney to President of the United States, every property owner has the right to file a tax appeal. And every client of yours, your firms, should be thinking every year when they get their tax bill, which states the market value, according to the county assessor, county auditor, they should be looking at that value, paying attention to it, and when they think that one of the circumstances we discussed earlier about overvaluation apply, they should be talking to somebody like myself or Holly or an appraiser and considering whether or not to file a tax appeal. This is our information. Feel free to contact us at any point in time. Pat and I write about tax appeal matters more than I think than anybody else in the state. On our website under is it legal resources? Articles. We changed the tab heading. Under articles, you'll find all kinds of information, good information about tax appeals. And if you have a question about a tax appeal, and you call me up and you say you're from PACO and came to the meeting today or attended online, I'll be very happy to answer the questions. There's no charge. Thank you again for your attention.
All right. Hey everyone, I'm Pat Heery. I work with Chuck. As he said before, I'm going to walk you through filling out the complaint against valuation form. This is more of a practical presentation, so feel free to stop me and ask a question if you have any questions or comments about any of the slides. So again, here's the form. It has 14 questions, plus you have to fill out the tax year, which county you're filing in, and whether it's an original complaint or, say, the school district filed a complaint against your client's property, you'd be checking the counter complaint box. At the bottom, you also have to have your attorney sign the form and have it notarized as well. All right, question one, very basic. Owner of the property. This is either going to be an individual or a business entity. If you want to check the deed, do some research, check the deed, make sure that that if it's an individual, if your client's an individual, make sure it's their name, not some LLC on the deed. So you want to make sure the deed and the name, number one, match up. If it's an LLC or some type of corporation, we suggest that you check the Secretary of State's business search to make sure that it's still an active corporation, LLC. I'm sure many of you are familiar with this website, but you go to Secretary of State, Ohio, click on businesses, business search, type in the first couple letters of the business name, and let's say it's ABC Driveway Co. Click on that. You see that its status is active. Now you know that you can file under that name. Questions 2 and 3. Question 2, you're generally not going to fill out. It's normally going to be the school district filing that. Question 3, you'll want to put your attorney's name, who's signing the complaint against valuation, and then you have their street address, state, and zip code as well. Question 4, we always put, instead of putting the client's phone number, we put our firm's phone number, because if there's any issues, we want the board calling us, not the client. Question 5, you're generally going to see that left blank. Occasionally, we'll see a form where the property owner's spouse filled out the form and they put spouse under number 5. But number 5 is basically an irrelevant question. Question 6, here's where you start to run into some jurisdictional pitfalls. You need to make sure that you put all of the parcels that you are asking for a reduction on. You want to make sure that the parcel numbers are correct as well. And list the address. And you'll see with question 8, you'll want to make sure that the parcel numbers that appear in question 6 are the exact same ones that appear in question 8. We've come across a couple situations where the parcels don't match, and then you have the potential to have your complaint dismissed for jurisdictional reasons. Question 7, what's the principal use of the property? You can find this on the auditor's website when you search for the parcel. I'm not sure this question is going to get your complaint dismissed if you listed it incorrectly, but you can find all of the different use codes on the auditor's website. Question 8, this is by far the most important question. It has 5 parts. If this question is messed up, you're in trouble. Your client's in trouble. Your complaint's probably getting dismissed. And the reason is, well, actually, I'll go through the 5 parts. Part 1, you list the parcel or parcel numbers that you're complaining about. These need to match up with question 6, as I said before. Column A, what price are you asking for? Say the auditor is valuing your property, or your client's property, at $1 million. You think it's worth $100,000, put down $100,000. It doesn't matter how ridiculous your column A number is, you can always amend this to you can always amend this at the BOR hearing. So what's your opinion of values? Question A, then take 35% of that, put that down for question B. Column C, you need to look at the tax bill or the auditor's website and get the taxable value. So you put that down under column C, and then column D is the most important column. What's the difference? B minus C. This number is going to be negative. If this number is above $17,500, as Chuck said, the local school district automatically is notified of this complaint, because that means that the property owner is requesting a reduction of more than $50,000 on the property. So the reason this question is so important is because say you do your math wrong and you end up with $15,000 in column D. Question?
Chuck mentioned $50,000 and you said $17,500.
So
can you explain how they relate?
$50,000 in market value equates to $17,500 in assessed value. So in this scenario, the school district would not be automatically notified of this complaint because column D is showing $15,000. However, if you did your math wrong, or if you just left this blank and the school district wasn't notified, and then when you show up at the BOR hearing, you're requesting a large reduction, your complaint will get dismissed automatically on jurisdictional grounds, and you also will not be able to file another complaint for the rest of that triennium unless you have a one of the exceptions, which we'll get to later. So it's a very important question here. Question 9 is just your justification for what you put in question 8. You can literally put anything here. Normally you're going to see stuff like property was sold in a recent arm's length transaction, neighborhood values, or comparable sales. Neighborhood values are declining. Say it's a high crime area, you might put that down. Questions 10 and 11. Question 10 was the property sold in the last 3 years. You can check this on the auditor's website. As Chuck said earlier, the best indication of market value is going to be a recent arm's length transaction. So that's one reason that question 10 appears on the form. Also, one thing to keep in mind is when it asks, was the property sold within the last 3 years, it's going off of the tax lien date. So if you were filing a complaint today, if the property was sold in 2014, you would have to fill out yes, it was sold within 3 years, because it's within 3 years of January 1, 2017. If you're filing a complaint where your client purchased a property, say for $100,000, and the auditor is listing it at $500,000, you'll want to attach you want to say yes, the property was sold on such and such date for this sales price, and then you'll want to attach the purchase contract, the deed, the conveyance fee statement, and the HUD settlement statement as evidence showing that this was a recent arm's length transaction. Question 11 just asks if the property's been listed in the last 3 years. It's pretty straightforward. Questions 12 and 13. Question 13 asks if there were any improvements in the last 3 years. Again, this is going from the tax lien date, not the actual date that you're filing the complaint. And we're talking about major improvements here, such as you're redoing your roof, you're adding an addition to this property. We're not talking about repainting the front door. One way to tell if it's a major improvement, you can look at the auditor's website, but a lot of times you can check if any permits were pulled on the property. And then you put down the total cost or the estimated cost. Question 13, do you intend to present the testimony or report of a professional appraiser? The reason this question is on the form is for the BOR scheduling purposes. If you're bringing in an appraiser as an expert witness, the hearing's probably going to take 30 minutes because you're going to have them testify. If you're not bringing in an appraiser, the hearing might be over in 10 or 15 minutes. So they're just asking that for scheduling purposes. Question 14, this was the exceptions question that I was referencing earlier. Say you filed a complaint today, you go before the BOR, you get a reduction. For tax years 2018 and 2019, the other two left in the 3-year triennium, you're not able to file a property tax appeal unless one of these 4 situations apply. The first is the property was sold in an arm's length transaction. Second is there was a substantial improvement added to the property. The third is the property lost value due to a casualty. We're talking major casualties here, flooding, a fire, something like that. And then 4, occupancy change of at least 15% had a substantial economic impact on the property. For instance, if you own this building and for some reason half the tenants left, that would be grounds for filing a tax appeal. There's actually a 5th exception, and it's anytime the auditor changes the value of your property. That doesn't happen very often. There's normally some reason, or there's normally in fact, I'm not sure I've ever seen it. I'm not sure. Chuck, have you ever seen?
One time.
One time. Okay, so if you have a client and the auditor randomly changed the value of their property, that is also grounds for filing a second appeal within the 3-year triennium. And here we're going to show 2 examples of complaints that were dismissed on jurisdictional grounds. Here there's a number of mistakes. The first is the person filing the complaint did not fill out number 6. They didn't put the parcel number. That alone probably doesn't get your complaint dismissed. The BOR can probably figure out which parcels you're complaining about if you filled out question 8 correctly. However, this person did not fill out question 8 correctly. They got the parcel number, they put their own opinion of value, and then they just left the other 3 columns blank. Here, the BOR receives this complaint, and they don't know whether you're asking for a reduction of over $50,000 in market value, and thus they don't know whether they need to notify the local school district of this complaint and allow them to become a party in this tax appeal hearing. So this person or this party with their name whited out, but they're out of luck for tax year 2009, and then they're also out of luck for any other tax years in that 3-year triennium. And here we have another complaint that had some issues. They didn't fill out whether it was an original complaint or counter complaint. That alone probably is not enough to have the complaint dismissed on jurisdictional grounds. They didn't have the parcel number in number 8, but they had it in number 6, so maybe the board allows the complaint to be heard. The main issue here, and you wouldn't know it from just looking at this complaint, but the property owner did not own the property at the time that he filed the complaint against valuation. You must own the property that you're complaining about when you file the complaint. So that's something to keep in mind for your clients. And then that can also spill into other things. If you're representing somebody who's selling a property or buying a property, you may want to consult somebody who understands how this process works, because say your client is purchasing a property for above the auditor's rate, their property taxes are going to go up. So you'll want to have the seller prorate the taxes, and it gets a little more complex here. But in this case, Mr. Vera did not own the subject property when he filed this complaint. Go ahead.
I have a question.
Sure.
So right now with the market of selling a house, people are referring to as eBay. People are offering way over what the value is in order to obtain the house.
Mm-hmm.
Is that gonna be affected a couple years down the road by the people who are paying like $20,000 of the value to get for the house?
Okay, so the question was, in today's economy, a lot of people are offering well above the asking rate or well above the auditor's rate when they go to purchase a house. Is that going to have some effect down the road? It could have an impact down the road. The issue is if you list your house for $200,000 and somebody offers to pay $300,000, unless there's some evidence showing that that was not an arm's length transaction, that $300,000 becomes the best evidence of market value. Maybe maybe the economy takes a turn for the worse in the next couple of years, and all of a sudden that $300,000 value is way too high. The new owner can file an appeal, and they can present other evidence such as an appraisal report or a list of sales comps from that area or from their surrounding neighborhood as evidence that, hey, I may have purchased it at $300,000, but that's actually, as of January 1, 2019, that's not the best evidence of market value. Does that explain?
Yeah, it definitely does.
Okay. So that was a good question, and that obviously happens when there's recessions. When I started working for Chuck, we were finishing up a number of the tax year 10, 11, 12 cases, because sometimes these cases, if they get appealed a couple times, they take 2 or 3 years to reach a final verdict. So we were seeing some of that where somebody purchased an industrial building for $5 million, and now all of a sudden they're trying to sell it, and they can't get more than $2 million for it. So we'd have them present an appraisal report, and that can become the best evidence of market value. And then, so if your complaint's dismissed, this is not the letter you want to get. You'll get a simple letter from the BOR. It basically just says your complaint's been dismissed, and basically you can't do anything. You can appeal this, but if you have jurisdictional mistakes on your complaint, you're not going to win that appeal, and you can't file any more complaints during that 3-year training. In case you couldn't read that. All right, that's all I have. Is there any other questions?
Yeah, just kind of going along with your question, is there a reason not to appeal? If, for instance, it may affect the marketable value, really, if you really want a good appeal and the assessed value goes down from the county, would that affect the resale value, and would you advise your client not to? For
Okay, so
specific reasons.
let me know if this is what you're asking. So, say the question is, you want to have your taxes reduced, your property taxes reduced, so you file a complaint, you're successful on that complaint, and the auditor's market value of your property is all of a sudden low, and then you want to sell the property. Is that going to affect the amount you can sell the property for? The answer is no. I don't believe so. I don't think that a lot of people look at at least with our clients, a lot of people don't look at the auditor's value of a property. And in many cases, it's not the best at the moment that you're selling the property, it's not the best, the best indication of market value is what can you sell it for. So if you file a complaint on your home and you get your property reduced from $300,000 to $200,000, go ahead and try and sell it for $300,000 when you list it, because another reason is property taxes are done a year in arrears. So today you're fighting about what the property was on January 1st, 2017. So the market value probably changed over the course of that 1 year. Does that make sense?
So actually, assessed value tends to be, in normal markets, it tends to be a little bit under market value.
Well, it's normally 1 year behind. So whatever the market did over the course of that year, it may be behind, it may be ahead. We generally, when I first started working with Chuck, that's what I assumed when one of my buddies was utilizing our services to purchase a house, and I looked at the auditor's rate and the auditor's value of the house, and I was like, wow, you're paying X amount, you're paying $60,000 more than what the auditor's valuing this property at. And Chuck was like, that is completely irrelevant when it comes to market value in the present day, as opposed to what it was a year ago or more than a year ago on the taxing date. Any other questions?
Yeah, there's a number of homes where I've seen that the auditor's square footage is incorrect.
Mm-hmm.
Would you just use that then as the basis of requesting the reduction?
Okay, so the question was, many times the auditor has inaccurate information on their website. Can you use that as the justification for appealing your taxes? You could, but in that case, you're probably going to want to present an appraisal report along with, or at least some type of appraisal evidence showing that the auditors...
Builders, blueprints and the schematics
Mm-hmm.
for the sale of the house.
Exactly. We actually just had a case on appeal where that became an issue. There was about 200, 300 square feet missing from the auditors. They had 200 or 300 more square feet in the property than what our appraiser had measured. And so we ended up reaching an easy settlement with the local county because we said, hey, I think your drawings are incorrect. Here's what the builder's drawings were. Here's what the architect's drawings were. Can we compare them to what you have? So yes, that can be grounds for appeal, but you're normally going to need to present evidence showing that difference, that discrepancy actually makes a big impact on the ultimate value of the
It's
property.
800 square foot and they're counting it as like a full 2-level house where
Mm-hmm.
it's a cathedral ceiling.
Yeah, so that in that case, it probably has, an impact. But again, you're probably going to have some type of expert witness testify to how big that impact is and assign a value to that discrepancy in order to win the case. You can't really just go in and say, hey, your numbers are off. Give me, a $25,000 reduction. They're going to say, why? Why is that? Where are you getting those numbers from? So, and also, if you ever see inaccuracies on the auditor's website, they have I think they have a email you can send, complaints to, or a number you can call and have those numbers updated. All right, I think it's everything. Thanks for having us today.
Well, thanks very much to Chuck and to Patrick and to Holly for coming and sharing some pretty good information with us. Thank you for attending. Thanks to Mike Mobley Reporting, who provided the lunches for us today. Thanks again to Anderson Reporting, who have been here to manage the technical aspect of putting this on live stream for those of you who are watching from your desks at work. We appreciate your attendance, and if you have any questions, please don't hesitate to contact one of the folks that spoke today or contact any of the PACO officers. If you have other questions, be looking for upcoming events, and we will see you at the next one. Thanks so much, everyone. Have a good afternoon.